Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Both partners are experienced trial attorneys who have been board certified in family law by the Texas Board of Legal Specialization.
All right, thanks for tuning into For Better, Worse, or Divorce podcast. This is Jake Gilbreath, and today I'm joined by Sarah Gilbreath, who is the CEO of our firm and also my wife. And we're bringing her on because we're talking about a very important process in the jury trial as part of our jury trial series. We're going to be talking about voir dire. So, Sarah, thanks for being here. And I guess for clarification, we just want to point out that while you're not an attorney, you've worked as a paralegal before becoming COO and then CEO of our law firm. And to this day, we still bring you to the process that's called voir dire in our jury selection and have you participate in that. So I guess let's start off with, I think you tell it better than I do, why we've discovered over the years it makes sense to involve you in that process. And then we'll go through talking about what the process actually is.
Yeah, so that was the longest intro you've probably ever given me in your life as your wife, but I'll take it. You probably bring me because I am judgmental, or I have very keen skills in assessing someone's character, and I am good at relying on my gut instinct.
Well, I think I would add to it. We have discovered, as you're being nice about it, we have discovered, and this will make sense when we talk about the process. We've discovered over the years that when it comes to actually making the final decision about who we're going to use strikes on, we'll talk about that in a second, but that you have had a much greater success rate than I have as far as anticipating who will be a positive juror for us. And that's been pointed out several times that I think we've had juries where when we figure out who we're going to use strikes on or who we're going to leave on our panel, I've gone one direction, you've gone the other. And like we often do, we sort of defaulted to your decision, and each time it's worked out tremendously well for us. In the times where I've been stubborn about my selections, that has not particularly worked out. Even though we were still successful in those juries, potential jurors that I thought were going to go one way, I did not have the read on it that you did, to be frank.
I mean, who's good for us or maybe who's bad, right? But I think I'm good at assessing who is going to be the leader in the group. So who is going to have the most pull, and then figuring out, are they good for us or are they not?
So let's talk about the actual process, because that will sort of help people understand kind of what we're talking about. So first of all, we're talking about jury, what people call jury selection. We'll talk about why this is in a second, but it's actually not jury selection. It's actually jury deselection, because what we're doing is we're picking who is not going to be on our jury. So let's start talking broad picture, right? In a family law case, like we've talked about in other podcasts, a jury can decide some very important questions. The main ones being for property, they can decide the character of property, is it separate or community? They can decide the value of property. That can be a very important question. They can decide the calculation of some reimbursement claims. They can actually decide fault or grounds for divorce. And then various fraud, breach of fiduciary duty, constructive fraud claims they can make decisions on, and some other things if there's torts involved that could affect property. On kid issues, they can decide, are the parents sole managing, is one parent sole managing conservator, or are the parents joint managing conservators? They can decide which parent has the right to determine the primary residence of the child, in other words, who has custody, and they can determine geographic restrictions. So some major decisions that a jury can make. And like we've talked about in prior podcasts with Brian, it kind of talking to other family law practitioners in other states, it kind of blows their mind that we have that we let juries decide that in the state of Texas. But our experience has been that's a very positive part of our judicial system. And oftentimes it makes sense for our clients to ask for a jury to decide. So let's talk about how somebody ends up on a jury, right? Because ultimately, what's going to happen logistically is that people, and some of you may have gotten this in the mail, you're going to get a jury summons. It's going to say you got to come down to the courthouse and you could potentially be on this jury. And then what the court administrator does is they'll take that from that jury pool, they'll assign, this particular number of jurors, potential jurors that are coming up, they're being assigned to this case, right? The Smith case in front of Judge Meacham in Travis County. She's hearing the Smith case. Here's her jury pool. And eventually, what will happen is there will be between about 45 and 60 people that are in Judge Meacham's, in this example, Judge Meacham's courtroom. And then the jury will come from that pool of people. And so we'll talk about what that looks like. But first of all, let's talk about the process in preparing for that, Sarah. We get what's called jury cards when the jury gets assigned, and we get assigned to a particular judge. There's jury cards that are provided to the attorneys. They give some background information on the potential jurors, and they're numbered. This is juror number one, Joe Blow. This is his gender. This is his age. Whether or not he's married, or this is his race, married or divorced or single. This is his educational background. Does he have children? Has he served in a jury before? Any involvement with law enforcement? What are his hobbies? What do his kids do for work? A lot of information on this one card that you get. Religion, what religion does he or she identify as, if any? All this information we're getting about somebody, and depending on your court, maybe the day of jury selection, it may be before, days before. So Sarah, we get these cards. I was sort of talking through process, right? That's kind of as from the lawyers and those assisting the lawyers. That's the first step in sort of trying to take notes on these strangers to figure out who could potentially be on the jury. So what's that process look like for you when you're first getting these names and you don't know who these people are, and you have all this information about them? What are you trying to capture?
So I have a different first step probably from you because I'm not now working on the cases day to day. So for me, I look at it first from the perspective of what is the case about? What is the conflict? What's in controversy? On a bench trial, so trying it to a judge, typically it could just be we have a disagreement. We need somebody to help us make a decision. But on a jury trial, for us at least, usually what I see is there's something bigger in controversy, something kind of controversial, a move, some big change to the kids' schedule, something really dramatic happened in one of the parents' lives. Could be drug use or whatever it is, right? Something very controversial. It's beyond just we can't agree and we need help. So the first thing I do is take a step back. Before I look at any of the jurors' information, I don't want to see any of it. I first want to get kind of the scoop on the case. So what is it we're asking for? What's the other side's position? How is everything kind of teed up for trial? And from there, I try to think about what the ideal juror would be before I start looking at who our candidates are, because I don't really want to cloud my judgment on okay, well, what's the best thing we can look for with what we have. I really try to narrow it down. If we were picking the ideal foreman for our jury panel, what would that look like? So that's the first thing I do. And once I can kind of in my mind figure out what the lay of the land is with the controversy on the case, then I look at the prospective jurors cards. And I have a whole spreadsheet that I use. There's certain things I look at and track. And for me, I look at their background, and I try to tailor it to whatever is in controversy. So if we're talking about we had one where a mom was using drugs in the home and also allowing the kids to use drugs in the home, and dad was like, whoa, not cool, kids need to come live with me. So on that one in particular, I was looking for people that maybe had more of a traditional background and family structure, people maybe that would list something for their religion. Didn't really matter what it was, but maybe somebody that would list something. And so I kind of tailor what I'm looking for based on the controversy of the case. And then the most important thing to me is initially trying to determine, just from these bare bones info that we get on these people on a sheet of paper, do I think they have a really strong personality, or do I think they're going to kind of go along with the process? And the next question I ask myself is, just initially, and this is one that I allow myself to change, are they on our side or not? And so that's how I kind of start to filter through people and figure out where they land.
Yeah, I think the terminology is leaders and followers, right? You're looking for, or you at least want to know, and we're looking at these cards trying to think what our senses of this person, again, having never met them, right? And sometimes we're right, sometimes we're wrong. Sometimes when you actually meet this and talk to this person face to face, your kind of read from their background is wrong. I mean, that's why we don't typically use stereotypes or want to use stereotypes in our day-to-day life, because it's often proven wrong. But you got to start somewhere, in jury selection, and that's the way we do it. And I know you do this, Sarah, and I do it too. I try to kind of look up their background, their occupation, kind of what they've been through. Have they been on a jury before, for example? Or um, you can sometimes read between the lines if somebody is kind of willing to participate in the process, and maybe they've been pretty verbose on their card. And then some people kind of intentionally leave them blank on everything, and you can kind of assume that that person's not the happiest camper, having been asked to fill this out for potentially being on a jury. And then I list them, and I know you do the same on my little spreadsheet. It's either a leader or a follower, and do I think this person is a positive leader? Do I think this person's a negative leader? Positive follower, negative follower. And then for me, it's also just trying to capture on this spreadsheet as much relevant information that I can. I mean, obviously, I want to know their age, gender, race, and then I put that in one column. But then, as far as like notes that really sort of stands out on their card, then I want to put that in the next column, right? If somebody has a postgraduate degree, that's something that usually jumps out and puts in the card. If somebody's a lawyer, that's a big one to jump out. If they're a medical professional, if they are a school teacher, those are the types of things that sort of jump out. And so you're sort of trying to capture as much relevant information as you can before you even meet these folks. Because then we're going to go take that. I guess I'll just give a nod to this for those that really want to nerd out on jury selection. Is once given the cards, you are given an opportunity by the district judge, usually with a deadline, to request a shuffle. And we'll talk about why this matters more in a second. But these jurors are given all with numbers, right? So you have numbers for the potential jurors, 1 through 45 or 60 or whoever's in your pool. And we'll talk about why this is in a second, but the ones at the beginning are more likely to be on the juror than the ones at the later numbers. And you have a right to ask for a shuffle only one time for the judge to basically mix up the numbers and reorder who's at the front and who's at the back. And so there's a strategy behind that, right? If you think that, wow, jurors number, there's a bunch of people that be positive for me towards the end, and they're not likely to end up on my jury, then I should shuffle this up. Or if I see a bunch of bad ones for what I think are going to be bad ones for me at the beginning, I should shuffle this up. Or maybe I'm fine with it. I don't use shuffle. Kind of a side note, not a big issue in jury selection, but that is something out there for those who really want to kind of know how the process works step to step. So after the shuffle, or there's not a shuffle, and you have kind of your final list of your jury pool, then we get to do that where the fun starts. We get to do what's called voir dire, which is as our district judges usually tell the pool, voir dire is the Texas pronunciation of voir dire, which either Latin or French, I should know, means to speak the truth. I don't need to know. This is Texas. It's voir dire. It's voir dire. That's what it means. So voir dire is the opportunity that these jurors come in. They come into the district court. They're all sitting on the benches. They've all got their numbers. They've been given, in most counties, a little paddle that corresponds with their number. And then the lawyers get to ask questions. And as the person that gets to do the voir dire, which, as an aside, that I am good at, as far as kind of voir diring and trying to figure out who's positive or negative. That's Sarah's strength. The actual voir dire, that's what I concentrate on as far as this process. But as part of the voir dire, the lawyers get to ask questions of these potential jurors. And the questions cannot be specific. They can't be what we call commitment questions. In other words, if I've got a custody case and I've got mom, I can't sit up there and say, well, here's the facts of the case and here's what the evidence is going to be. So who here would vote for my client of having custody? I don't get to do that, right? I get to ask more general questions about their background. And we'll talk about what those questions are in a second, but now it's time to talk about why we're doing this. and why we call it deselection, jury deselection, and not jury selection. Because the way a jury is impaneled is you have these potential jurors, again, usually 45 to 60, depends on what court you're in, or it's county court or district court. But let's just use district court for all these examples. So you can have 12 jurors. You got 60 people out there. Let's say it's 60 people out there that potentially could be on the jury. At the end of voir dire, having asked questions, having read their jury cards, having done all the background work that we do, ultimately, I get two types of strikes. I get what's called a strike for cause, and those are limitless. And I get peremptory strikes, and those are, I only have 6 of those in district court. So, a strike for cause is I'm striking somebody because they have a bias that they cannot put aside that's going to impact their ability to serve as a juror. By way of example, if I represent dad, and out there there's a juror, they never say it like this, but out there's a juror that says, hey, at the end of the day, I think mom should have custody, right? I just think that's the way it's supposed to be. Mom's supposed to raise kids. So it doesn't matter what you tell me. Again, they'll never say it this explicitly, but doesn't matter what you tell me, mom should have custody. Well, we're gender neutral in the state of Texas, right? The law is that we don't take into account gender in determining custody cases. So that person has a bias that's going to impact their ability to follow the law. And so that person could be struck for cause, right? That you just can't, like, you're not allowed to serve on the jury if somebody motions for that person to be struck for cause. Or somebody stands up and they said, I know, I know the party, I know the wife in this case, or I know the husband in this case, or I know this critical witness. That person could be struck for cause. Um, and again, those are limitless. The peremptory strikes, or each side has 6 that they get to use, and really for whatever reason. They can't strike somebody based off race, but otherwise I can use my peremptory strikes for any reason. Somebody's told me something about their background, or their card gives me information that I just think this person's not going to be a good juror, and I can use it for whatever reason, right? I don't like the shoes you're wearing. I'm using my peremptory strikes on this person, right? It's just, I don't have to have a reason. Again, it can't be race based, but I can use my peremptory strikes. So that goes back to what we said as far as how the jury comes about. I use, if we have a jury trial and I use 6 peremptory strikes, the other side uses their 6 peremptory strikes. There's strikes for cause, or people that are just let go because they're biased. Some people no show. Some people have medical reasons they can't be there. Some people have economic reasons they can't be there. After all that sort up, and kind of those who are remaining after we've done cause, peremptory strikes, medical leave, economic leave, um, those who are left standing, the first 12 left standing are going to be your jury, and then maybe an alternate. So that's why we call it deselection, because at the end of the day, I'm not looking out this jury pool and telling the judge, judge, I want juror number 3, I want juror number 10, I want juror number 15, 37, 52, blah, blah, blah. I'm not doing that. I'm saying, judge, I don't want these 6. And the other side says, judge, I don't want these 6. And by the way, we don't compare notes before we come up with our 6. And then who's remaining is who's on the jury. So if you think about it sort of mathematically, back to that point I made about those at the beginning are more likely to get struck, we actually have something that's called a strike zone, because if you think about it mathematically, once you know who's out for cause, once you know who's out because they've been excused by the judge for medical or economic reasons, and you're looking at who's left, those who are left mathematically, the jury pool can only come from the first 24 remaining. Because even if I use 6 peremptory strikes on somebody completely different than the other side uses their 6 peremptory strikes, 6 plus 6 is 12. So at a maximum, 12 are out. So at a maximum, 12 can be remaining. No, at a minimum, 12 can be remaining. And then that's where your jury comes from. That's a lot of information to say. That's why we're doing voir dire. So Sarah, what would you add to that until we talk about the actual process of voir dire and what we're looking for there?
Yeah, I mean, I would back up a little bit to say, so voir dire is French, and it means to speak the truth or tell the truth. So when you were talking about that as your strength. I mean, I think that's true. I think your strength is, and this is hard, but it's to connect with people individually and collectively. And so the hardest job that you have, or any of the attorneys trying the case has, is to connect with these people, get them to speak the truth, to get them to say something, right? So that we can kind of get more information than what we have from the cards. Because you're right, what we have, we can read it one way, and probably about 40% of the time I am like, well, I was completely wrong about that one, once we get them engaged in communicating. And so I think there's kind of two reasons you're really good at that. Number one is you have an innate ability to connect with people, again, individually and collectively. But I think you also have allowed yourself to step back from the process and just do that. So just asking the questions and just connecting with people, listening and following up to things that they're saying is really important. But it's a lot. There's a lot of people. They're all raising a paddle. So for someone that's never been to one of these before, you may ask a question. How many of you lived in another state from one of your parents, right? And we're going to have paddles all over the room. Could be 40 people that raise their hand, or more. And we're writing all of those down, and we're tracking those with the question to kind of figure out how that works with what our position is in the case and who's going to be favorable for us. What is their response? Because just because they're saying yes to a question doesn't mean that they're in favor or against, right? And so then us kind of watching people, figuring out how they're responding and giving you that information in real time to know who to follow up with and how to do that and track everybody. It's a big job. So just again, taking a step back, I think having the ability to connect with people, really listen to understand, and then follow up with who you need to is the key to getting the information you need to make good choices on who you're deselecting, which is what people always ask me. How do I not get on a jury? The answer to that is really say nothing, right? But we're going to do everything we can to get those people to engage. And the other thing I will say about that is when I see you do it, I don't see a lot of other people do it. I help a few other people in town, but people generally enjoy the process more than they think they will. Once they get in there and they hear the kind of questions you're asking and their ability to kind of feel like they're contributing, I see a lot of people open up and speak a lot more than maybe what you might expect. So that's the kind of things that I'm looking for and doing while you're asking the questions. And it's not just, and I'll let you talk a little bit more about kind of the questions you ask, but it's not just listening to the answers, but how that interplays with our case, and looking at people's body language and figuring out, how do they feel about you? Because you and I have had differing opinions on, I think, that as well.
Yeah, and we default to yours because I guess, in fairness to me, it's always good to be fair to me. In fairness to me, my job is to kind of follow up and ask the questions and stuff in voir dire. I can't ask questions and take notes and kind of read how they are reacting and stuff like that. My job is to elicit information as much as you can, right? And we say that when we're talking to the potential jurors before we even start. We say, look, at the end of the day, most people don't love the idea of speaking out in front of other individuals, right? That's just how we are as humans. Most of us don't like public speaking. I tell people when I'm doing voir dire, I'm not a huge fan of public speaking in social interaction. I always tell people I'd prefer to be on a Zoom call with somebody than in a courtroom in front of 60 people talking about my personal life or their personal life and what have you. But once we get into it, people do tend to enjoy it. But what the goal is to get folks to share as much information as possible, so I can, because after my voir dire, the other side's voir dire, we are going to make a decision if this person, we think we should use a strike on this person or not. And so, to Sarah's point too, right? You want to, the more you share, the more, frankly, the more likely you're going to be struck, right? If you share a lot, you're going to say something that the other, one side or the other is probably going to, have a, it's going to ring a bell on their side and say, maybe I don't want this person. If you sit there silently and just kind of sulk, well, you're probably a follower, probably not going to, sway the panel one way or the other. So I may not use up a strike on you. And so the goal, but again, overall, the goal is that you're trying to get people to talk and share as much as possible. Because I'm searching out there. Sarah, the associate, any paralegals that are helping, are searching, trying to find the jurors that are bad for us, right? That's the counterintuitive part that you see a lot of people that haven't done jury trials before. Um, One of the many mistakes that they make, and we'll talk about this sort of towards the end, why it's so important to have this experience, because there's lots of mistakes that you can make in a jury trial. You can make devastating mistakes in voir dire if you don't know what you're doing. That'll just tank your case. But a mistake that people that haven't done them do is they use voir dire as trying to find jurors that are positive for their what they view as positive for their case. Well, I'm not trying to find jurors that are positive for my case, because if I do that, if I illuminate that, then I'm just highlighting to the other side who they want to use their strikes are. I'm trying to find all the people that are bad for my case. Again, it's is an easy sort of stereotypical example. If I've got dad, I want to find every single juror out there that deep down thinks that mom should have custody. All things being considered, I want to find those people, and I want them to feel comfortable sharing that. I don't want to hit them over the head with a mallet and say, "How dare you? How could you think that? The law is that's supposed to be gender neutral, and that's just you need to follow the law." And judge, I move to strike this person for cause right now, right here. Well, if I do that, right, everybody watching what I just did to juror number 12 is like, I'm not going to raise my paddle and get screamed at by Jake. And so they're hidden. What I want to do is find the people that agree. If I represent dad, just in this example, and juror number 12 just said, "Hey, I think moms should get custody, all things being considered." Okay, who here agrees with that? I want to know everybody that agrees with that, because I want to find those people so they can be excused. That's the counterintuitive part. And that's where I see a lot of people mess up. So, how do we do all that? It just sort of depends on your issues, but I have sort of standard questions that I ask every single potential jury. Who knows the parties, who knows the witnesses, if there's mental health professionals involved, if they have experiences with mental health professionals, feelings about them, move cases. You talk about people's background, where they grew up, custody cases, who's been through a divorce. This sort of standard questions. Again, we're trying to get people to share and figure out their background. And then each case is going to have kind of tailored questions. Again, not commitment questions about the case specific, but to the example you gave, for example, Sarah, with drugs. I mean, a lot of times we see marijuana being an issue, or maybe one parent uses marijuana, or both do, or the kids have experimented with it, and then you voir dire on what are people's thoughts about that, and the legalization of marijuana. And depending on which county you're in the state of Texas, you'll get very different answers.
Yeah. I mean, that's what I was going to say too. Is it's nuanced, so it depends on the county. I mean, we are primarily in Travis, and Travis is contiguous to Williamson County, and Williamson and Travis are two very different jury trial settings for us, right? Um, we are going to approach a case very differently, uh, typically when those kind of issues come up, based on the county. And I think that's a huge mistake people make, is they kind of fall into this trap of this is how you try a jury trial, and this is how it's done. And you really need to know so much more about the nuances that go into how people make decisions and how they kind of think about things.
Yeah, and ultimately it comes down to why all this. This is so important, because it's we're all human, right? We can have two perfectly capable, competent people hear the exact same facts, and it just strikes them differently. It just does. They have different something in their background, something about kind of their moral fiber of how they view the world, that it's just going to strike this person differently. And so it's so important. I mean, there are studies and people that will tell you that a case is won and lost in voir dire. I don't know if that's totally true, but it's a big, big impact. And if you don't know what you're doing, or you don't take care in preparing, then you really could accidentally tank your case before it's even started, or put yourself at a serious disadvantage when that doesn't have to be the case. There is a science and an art form behind all of this, and it takes a while to get used to. I mean, Sarah, you and I have done countless voir dires, right? But the way I do voir dire now is very different than the first voir dire I did. You learn as you do it, and you get more comfortable doing it. And I think that's one of the reasons why we get called in a lot, sometimes by colleagues to co-counsel and help them with that process, or the entire jury trial, but help them with that process. Um, because we have the ability to, we've done it before. We can do the voir dire. We can have you come. We can have staff members come and kind of give that assistance, even in situations where it's not our case from start to finish.
Yeah, and I think you have to always be willing. Well, two things. You have to always be willing to evolve, and you have to be willing to kind of let go of your personal opinion about something. I mean, it's so easy to get locked into the idea of, this is what the juror should look like. And so this person is that person. And no matter what they say, I think they're good for me. You have to be really flexible, I think, in your thinking. And realize you're talking to a group of people that have very different experiences and come into this with all different perspectives from all over the world. And so having that flexibility in your thinking, which can be hard to do, particularly probably in our profession where we look at things as black and white, right and wrong. I think that's a muscle we have to exercise. And then, to the point of evolving, I mean, yeah, I've been in this industry now for 19 years. And I would say that cases today are in many ways very different from how they would have been 19 years ago, right? The laws have changed. Family structures look a lot different, thankfully, I think, over time. There's lots of things that are different now, and look very different than they would have 20 years ago. And so I think it's important to have experience and expertise. And I think it's also important to always be willing to look at how you do things and continue to improve them. You can see lawyers that have done it for many, many, many years, and they're going to do it the way that it's always been done. And I see that not really work so well with today's jurors, particularly at a time when people are coming into it with a lot more, I think, access to information and understanding about the process.
Yeah, absolutely. And each one looks different, right? You have to be willing to pivot, and just like you said, willing to just, maybe I had this person as a leader, triple positive before we start the voir dire process, and then at the end of it, this person, I think is not going to be good for our case. And then last thing I'll say, and then we'll wrap up, is it really is a team effort too. I mean, I've done voir dires where it's solo and just me doing it. Kind of earlier on in my career, I've seen people do that. That's a big challenge, right? Doing it just by yourself, and not having assistants, a good staff, or being able to bring somebody else in to help out, just because there's so much information, so many balls up in the air, and the voir dire process. I would be, as a client, I'd be really nervous if my lawyer's plan was to roll into voir dire, solo without the assistance. I mean, I think I'm very good at the process. I wouldn't do it solo. I don't like doing it solo. I don't think it's as good a product. I think I contribute something to the process, and then Sarah contributes something very different to the process. Staff contributes something different to the process. Even the client contributes to the process. But that teamwork, is what is really what gives you the best product on it. So, to wrap up, for those that are thinking about or have discussions about, with their current counsel, or their, whatever the situation is, and they may be headed to a jury trial, it really is important to kind of, one, educate yourself as a client, but two, have the frank discussion with your lawyer. Just no different than if I had a doctor operating on me. I'd probably want to know if this is her first time doing this operation. Is she going to have any help with the operation? Or are we winging it for me on the first time? And then what's the plan, right? What's the plan to bring in help, and bring in some experience to the process? Because it is difficult. I think it's, for me, the most enjoyable type of case to try. And I know, Sarah, you've sort of had the same experience as far as all the various trials that you've helped out over the years. I think that jury trials, correct me if I'm wrong, have been kind of your favorite as well.
Yeah, I think so. And to your point, I mean, we've talked a lot about how jurors come into this with different perspectives and different backgrounds, but we do too, right? So your point about, needing it to be kind of a team environment, I think is really well taken, because one person has one experience or set of experiences, one perspective. And, just like the jurors have come from all walks of life and have different experiences, I think it's important that your team look like that too and have those different varied experiences. I mean, you and I are married to each other. We have kids together. We've built a life and a business together. And we probably disagree as much as we agree when we look at these things and talk about kind of our perspective on things. And so I would just think about that. If I was the client, I would want, people with all different levels of experience and expertise and different walks of life, looking at my case and looking at the people that are going to be making a decision for my life.
Well, I'm sure there's tons more that we could talk about. Again, it's a very complex but interesting process. But we'll sort of leave that as the overview and wrap up with that for today. So thanks again to Sarah for joining us today. And then our third and final episode in our jury trial series will be in a couple of weeks. So stay tuned for that. As always, if you have any questions about this or follow up, you can contact our law firm, or you can reach us at podcast@waltersgilbreath.com. Please leave us a review. That's very helpful. Suggestions are helpful. All our links are out in the bios. And so feel free to reach out in any way. And thanks for listening.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreath.com. Thanks for listening. Until next time.